Welcome to Legal Listening, where audio obiter is our thing. We're Carly and Zach, and we're so glad you're here with us today. Today we're bringing you a special bonus episode, brought to you in collaboration with the folks over at the Legal Writers Collective. Go on and check them out on our website or at legalwriterscollective.com. Hope you enjoy. The Queen and Vuong. Heard August 10th, 2020 by video conference. On July 5th, 2018, the applicants were convicted of defrauding numerous investors over several years of more than $5 million in an elaborate investment scam in the nature of a Ponzi scheme. On October 28th, 2018, they were sentenced to 6 years imprisonment, less credit for strict bail conditions and pretrial custody. The trial judge ordered that they pay a $3,565,992 fine in lieu of forfeiture. The applicants have appealed their convictions and sentences, raising the following issues. 1. The trial judge erred in dismissing their Section 11B charter application. 2. The trial judge erred by not requiring the Crown's forensic accountant to be qualified as an expert witness. 3. The pretrial application judge erred in denying their Robotham application. 4. The verdict is unreasonable. 5. Their sentences are demonstrably unfit. The applicants seek the appointment of counsel under Section 684 of the Criminal Code, or in the alternative, partial funding for counsel to assist them with their appeal. They say they were hampered in their defense at trial because they were not represented by counsel and are unable to represent themselves adequately on their appeal. They claim they are indigent. The Crown opposes their application. In order to succeed on their Section 684 application, the applicants must satisfy the following criteria. 1. It appears desirable in the interest of justice that they should have legal assistance. And 2. It appears that they have insufficient means to obtain the necessary legal assistance. See the Queen in Adams and the Queen in Staples. I am not persuaded that the applicants have met these criteria. First, the applicants have not demonstrated that it is desirable in the interest of justice that they should have legal assistance on their appeal. That it may be better or easier if the applicants had counsel, however, is not the test. The question is whether the applicants cannot effectively present their case on an appeal without the help of a lawyer, or the court cannot properly decide the case on appeal without assistance from counsel. I am not convinced that either factor applies here. The issues raised on appeal are discrete and straightforward, and for the most part, were already canvassed at trial. The applicants do not require assistance to understand the myriad fraudulent transactions that they created and put into motion. They are intelligent, articulate, and well-educated. They showed facility with the relevant facts and legal issues at trial and on this motion. They are capable of advancing their claims of error before a panel of this court, and the court does not require the assistance of counsel to determine them. Second, the applicants have failed to provide adequate evidence of their financial need. They have not demonstrated that they have exhausted all other means of paying for counsel, including family members, and the legal aid process, nor have they been clear and transparent in disclosing their financial affairs. As Appeal Justice Gilles noted in Staples at paragraph 42, the applicants, quote, cannot satisfy their burden of showing that they have exhausted the legal aid process when their rejection was due to their own incomplete financial disclosure, end quote. That is the case here. The applicants were denied legal aid for their appeal based on financial ineligibility. In its March 29, 2019 letter, the Provincial Appeals Office of Legal Aid Ontario explained its reasons for upholding the Area Committee's refusal of legal aid certificate coverage. Quote, because both you and your spouse have been without income for a considerable period of time, legal aid presumes you still have access to other financial sources. Given the nature of your charges, the potential case cost, and the fact that they have thus far assisted you financially with shelter, living expenses, and legal fees, and have acted as your sureties, legal aid considers your mother, in-laws, family, and friends as part of the assessment for the purposes of financial eligibility. Their income and assets are presumed to still be available to assist you with legal fees. In the event that these individuals are now unable to assist you, they must attend for financial assessment in order to confirm this, end quote. Although the applicants dispute their relatives' assistance with legal fees and their continuing ability to assist them financially, they do not dispute that they have provided them with financial assistance. More significantly, there is no indication that the applicants' family members have attended for the financial assessment proposed by legal aid to confirm that they were unable to provide financial assistance. Moreover, notwithstanding that the applicants understand the necessity for making full financial disclosure, they have failed to do so. The bald statements of impecuniosity contained in Mr. Quach's affidavit on this motion do not satisfy the applicant's burden. Nor do the applicant's 2 recent personal bank statements or the short excerpt from the Ontario Securities Commission's forensic report provide the necessary support for their claim of indigency. As noted by Justice Hill in his reasons for dismissing the applicant's Rothbottom application, they maintained numerous personal and corporate bank accounts in Canada and around the world. There has been scant and inadequate production of these documents, nor has any real effort been made to explain the disappearance of the millions of dollars from the fraud. For these reasons, the application is dismissed.
Thanks for the listen, friend. I hope you're able to enjoy that case and learn something new from it. Legal Listening is founded by Zach Battiston and Carly Lyons. It is hosted by Zach Battiston, Carly Lyons, and you, our listeners. Executive produced by Zach Battiston, Carly Lyons, and Anthony Radomile. Audio engineering by Anthony Radomile. Graphic design by Julie Lundy. Check her out online at julielundyart.com. And music done by Matt Radomile at radandkel.com. At Legal Listening, we're always open to new ideas, suggestions, and of course, guest readers. Check us out on Twitter at Legal Listening or online at legallistening.com. Legal Listening, where audio obiter is our thing. We'll catch you in the next case. Bye now.